Welcome to the Probate Professor.
Hey everyone, welcome back to an all-new installment of the Probate Professor with attorney Taylor Waite over at the Clear Counsel Law Group. I am your host, Mike Leon. You know, navigating the Nevada probate system can be a little overwhelming, but you don't have to do it alone. Taylor is here to help, and he's been helping Southern Nevada families clear the legal hurdles and protect their legacies with confidence and clarity. Taylor, it's good to see you as always. In this episode, we're going to talk about a term that I'm not familiar with, but you're going to explain it, and that's the personal representative and what the role really involves. So let's dive into this. What the heck is the term personal representative with respect to the Nevada courts? Is it a fancy title like an executor, or is it something else that carries a little bit different weight in some of these counties in Nevada?
Hi, Mike, and really thanks for having me again today. That's a great question. Personal representative, it is the broad term in Nevada. It's the person that's been given authority by the court to manage the assets of the estate. And that includes, what can be confusing for people is when you use the term personal representative, it includes both the term executor and the term administrator, as well as some others. Really, for our purposes, those are the two important ones. And really the distinction between those two terms, executor and administrator, it has more to do with how you get the job and less to do with the actual day-to-day operations. The important distinction being an executor is the individual that is identified in a will as the person that the testator wants to be in charge. That is an executor. So if you're listed in the will, you are an executor. If you are not listed in a will or there is no will, then you are an administrator. So really, again, the important distinction, it's how you get the job. The court is still going to approve it either way, but they are both personal representatives. And both are going to have the same duties and responsibilities at the end of the day. And there is some important nuance, and I think we'll get into some of that today. But to answer the question, executors and administrators, the difference is how they get the job, but they're both personal representatives as the broader concept that they are in charge to manage the probate estate and work it through the process.
Well, Taylor, let me ask you a follow-up to that. And that's really, what about the personal representative if they live in the state of Nevada versus if they don't live in the state of Nevada? So relative that passed away in Las Vegas, they named this personal representative, but they live in a different state. Are there extra legal hurdles that are associated with that?
And that's a great question that gets into some of the nuance between an executor and an administrator in Nevada. So if you are the listed executor in a testator's will, then your residency is not an issue. So that can be, you could live in any state in the country. You could also live outside of the country. We've had executors that have lived in the UK or Australia, and they are able to serve in the state of Nevada without either being a Nevada resident, or we'll talk in a minute about having a co-administrator. But if listed as an executor in the will, you can serve without being a local resident. Again, that nuance though, if you are not listed in the will, or you are the administrator on some other qualification, then Nevada law is going to require that either one, you are a Nevada resident, or two, going to require that you coordinate with a local co-administrator that will give you that local connection. It is sometimes a frustrating distinction that, some would argue that they want to do away with the requirement. The court's concern, I think they're trying to address the concern of having someone that is local and is willing to work through and fully work through the process so it doesn't stagnate in the middle. Arguably, someone that's listed as an executor will have more of an incentive to finish, whereas an administrator, I'm not sure that it's a really important distinction, but that's the legal distinction right now.
So Taylor, on this front, let's talk about something you just mentioned about a will. Let's just say someone dies without a will. Who has then the kind of, and I'm using air quotes, priority to kind of be the boss of the estate? And how does the law favor, whether it be a surviving spouse or maybe a child, et cetera, with respect to petitioning the court to take over for the person?
This is the first fight, so to speak, that people can have when you initiate an administration. And if I can take just a minute, it might be a good opportunity to address just quickly the general qualifications to serve as an administrator, a personal representative in the state of Nevada. I hate to say it this way, but the bar is actually pretty low. The qualifications are that you are an adult, a competent adult, and that you're not otherwise disqualified to act. That seems like a strange way to say it. Sometimes you'll hear people explain it, so you're an adult and not a felon. But the reality is, the legal reality is that even a felony doesn't absolutely disqualify you. It can. What it means if you have a felony is you have to disclose that to the court. And that's true whether you're listed as the executor in a will or if you're just seeking court approval to be the administrator, you have to disclose that information to the court. And then the court has discretion to decide who is going to act as the administrator. So then back to your question of priority to act. The first priority is, of course, an executor that's named in a will. If you are named, then the court is going to give preference to that. Otherwise, there is a statutory list of priority that's going to track the way you would expect it to. And your question intimated that. So a surviving spouse will have priority over everybody else. And then the list goes down the way you would expect it to. First, a spouse. If not a spouse, then a child. If not a child, then a grandchild, on down the list. And it goes all the way to a creditor. So a creditor may have a priority to act and a reason to act as an administrator in the state of Nevada. Nevada also has, many of the counties have public administrators, and those are included in that list of priority, all the way down to the very last person, which is the very last one on the list, which is basically anyone that qualifies to act. Could be a neighbor or a friend, or honestly, just a random person. We've had some recent changes in Nevada statutes where if you are that very last person in priority, you have to give the court some additional information about your efforts to find family and to explain why it is you need to manage the estate. But there still is a goal that these estates where family or others may not be willing or simply available to do it, the courts still want you to get through the process. An important point here, too, is the question of whether or not someone that has priority wants to serve. So Nevada law does allow someone that doesn't want to serve to decline. Say, hey, I don't want to do it. And then they can nominate someone that will actually step into that priority position. So a surviving spouse could nominate a friend or their husband sometimes. So they can nominate someone else to act if they are unwilling or unable to do it, which one good example to bring up that we often run into, and Nevada's recent statutory changes address to some degree, is if you remember the qualifications, you have to be an adult, a competent adult. So we often run into a situation where you will have no surviving spouse, but you will have minor children. So a minor child wouldn't otherwise qualify to act. A dispute can arise between a parent or a sibling of the decedent, suggesting that they should have the right to act. But the way the statutes have changed, and the courts still consider a lot of the relevant factual scenarios, but the question becomes is whether or not that a parent of a minor child would have priority over a sibling or a parent. And it's a factual question. The court's going to consider that, but there can be a fair amount of nuance in a simple question of who should act and who should step forward to take care of it.
Taylor, let me ask you, just as a one-off, can a personal representative be held personally liable for some things? Like let's say maybe their own bank account is at risk. If they were to make a mistake during the Nevada probate process, are they personally on the hook for anything?
You know, the administrators that are listening in or future administrators listening in would love for that answer to be no. But the legal reality is that the answer is yes. They can be personally liable. But it is based on their conduct as administrator. It's a reasonableness standard. If they take on that role and they will give the proper notices and really do their best to adhere to the rules and the laws, and they have some obligation to educate themselves. Nevada law does not require that a personal representative retain an attorney to go through the process. That's true. But the court is going to ask them to follow the requirements to give proper notice, to manage the assets, to deal properly with creditors. So it's a question we often get, and some people are worried about it, and we tell them the same thing. You need to be diligent in your efforts as administrator. The court is not going to ding you for market conditions, for example. The value of a home drops, you're not going to be liable for that. But if you fail to disclose proper information as an intentional matter. Again, negligence, there's still some nuance there. But yes, if an administrator is willing to take on the role, fulfill the responsibilities, do the work to determine the information, talk to the banks, identify the creditors, and make a reasonable effort based on their understanding and experience, then any liability is typically going to be isolated to the estate and will not transfer to the administrator. But they do need to do the job and understand that they are taking on fiduciary obligations, not just to beneficiaries, but also to creditors and other interested parties. And so it is something to consider when they are deciding whether or not to take on that role.
Taylor, can I have you expand on some of that? Like, let's talk about the day-to-day of what a representative would be doing, because you mentioned a little bit about fiduciary responsibilities. So are they responsible for, clearing out the houses, talking to the IRS if there's some unpaid debts there, managing yard maintenance on an estate property? Like, what are some things that would be part of the day-to-day responsibilities?
That's a great question. And again, a question we often get when you're talking to people that they have regular jobs and they have kids and other responsibilities. So how much time is it going to take? And so you really hit it on the head. Sometimes the way we like to describe it is if someone brought you in to wind up a business, there's some sense, many people or most people would have some idea of what that would entail. And wrapping up a probate estate is much the same. You're going to manage all the assets, put your arms around what the decedent owned. Do they have to be liquidated or sold? Are they going to be transferred? Identifying creditors and dealing with and addressing with those. And then one of the important ones too, and oftentimes the one that is the most struggle, is dealing with the expectations of beneficiaries and creditors and things like that. So those make sense to people, but some that you hit on that they also have a responsibility to do. And some examples of things our administrators have had to deal with, right? So appraising odd items, which could be jewelry or just precious stones, memorabilia, or the sale of such items, which isn't always easy, and that can be included. Administrators are often tasked with defending lawsuits or pursuing lawsuits, so they will coordinate with attorneys. As you indicated, they're working with CPAs or other tax professionals to deal with IRS issues or the filing of taxes. And then what might feel like more mundane things, but you referenced some of those, they could be coordinating with contractors or landscapers to paint or clean up trash. But all of that, it's part of those duties. And again, you're making a reasonable effort. So it's an important consideration when someone's looking at taking on that responsibility that you look at what that's going to include and really doing it to the best of your ability.
Yeah. Taylor, when I hear the word duties, I'm like, I should be compensated for this, because it sounds like it's a part-time job. Does Nevada law at all allow for the person to be paid for their time doing all of this for the estate? And if so, like, how is that kind of calculated?
Absolutely. The administrator is entitled to be compensated for that work. And there's a distinction between what the courts refer to as sort of ordinary work in a very straightforward probate. And right off the top, no question, the court's going to give an administrator what's considered the ordinary fee, which is based entirely on the value and a percentage. Roughly, the idea is it's 4% of the first $15,000 in value, 3% of the next 85, and then 2% above everything else, on top of everything else. And that is just the ordinary work. So if it is the straight, just ordinary probate, the court is going to approve that. But in addition to that, if we go back to what we were just talking about, if you're dealing with defending a claim or pursuing litigation, or there's an extensive process of selling a home that includes dealing with contractors, issues like that, an administrator can ask the court for extraordinary fees on top of the ordinary fee. The court is going to expect an administrator to track their time, so they're going to have to give the court a basis for what they're asking for. I spend X amount of time, I'm asking for a fee of this amount, and give the court an explanation as to why they're entitled to that. The courts will historically allow for that if you can explain it. There's also, I think, a good spot to explain that if an administrator pays out of pocket, something like they're making mortgage payments, or maybe they've paid attorney's fees out of pocket, utilities, other expenses that relate or advance the probate estate, then those are also reimbursable to the administrator. Because the idea is they should be made whole both for their time and money. And the Nevada law certainly supports that idea that they should be compensated. Though the last thought on that is making sure people understand, sometimes we'll have an administrator that's also the sole heir of an estate. So we'll often suggest that they forego the administrative fee because it's a taxable event. You're doing work and you're getting paid for work. So that's reportable to the IRS. But if you're the sole heir, then it's typically better, in my opinion, to say, I'm not going to take it as a fee. I'll just take the full distribution, because the inheritance typically is not a taxable event. So that's an important consideration. They don't have to take it, but they can, and they should understand if they take it, that it is a taxable event that's going to be reported to the IRS.
Taylor, as we kind of wrap on this episode, let's talk to that person that maybe they're named in a will right now, and they don't want the stress that they just kind of heard you kind of outline a little bit of the job. How would you advise that person to kind of, I guess, decline the role without maybe causing a legal mess for the rest of the family?
Mike, I think that's a great way to ask that question. To decline it in a way that doesn't cause any legal issues with the family, because the law does not require you to take on that role. I've had that conversation on the phone with many clients who they're looking at an administration that is going to be time intense and going to require a lot of them, and they just don't have the time, but they're listed in a will as the executor. So what I explained to them is they do not have a legal obligation to take on that role. They do not. They can decline, and in many situations they should decline and allow for someone else. But some important considerations, if we go back to that idea and that distinction between an executor and administrator. So typically most wills are going to identify a primary person. This is the first person I want as the executor. If this person can't do it, then someone else is going to step in to do it. But we have had situations where the person that's first listed as the executor, they don't want to do it, but they do not want the second person involved, or the family generally, for whatever the reason. The reason that's an important consideration is if the testator that drafted the will identifies, let's say, two people in the will, I want this person to act, if not John, then Mary, but nobody wants Mary to do it. The problem with John declining is the court will say, look, what the person said is, I want then Mary. And that's how the courts will go if we go back to the priority question. So it's an important consideration. But then outside of that, if we go back, and we did talk about that or touched on that, someone that's identified statutorily to having priority, it really is as easy as them saying, hey, I decline to serve. And that can have two effects. If they just decline, like, I don't want to do it, sign that document, then it's going to move down the priority list to the next person. But they can decline and nominate. And the effect that has is if they decline and nominate someone else, then statutorily that nominated person would take the place of the person that declined. And there still may be a dispute in that respect, because then you may have, if you have two children, for example, one who has authority to act and then one who had authority but nominated someone else, the court may still take preference or have a preference for the child over someone that another child nominated. So that's an issue that may play out. But it's not difficult to decline to nominate, even if that does give some other issues that are going to have to address.
Yeah. Well, Taylor, we appreciate the time and the insights and breaking this down for the audience. Thanks as always.
Thanks, Mike. Always good to be with you.
And thank you again for everyone listening to this episode of The Probate Professor. If you're navigating a probate matter currently in the state of Nevada, don't let that legal process overwhelm you. Visit Taylor and the team over at clearcounsel.com to get that clarity you need and connect with them right away. And do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.